Good afternoon, everybody. Michael Smikun here from Callagy Law, and with me in the room I have Sean Callagy, Dan Nowak, Tiffany, and Nicole as well. So for those of you who are on our last webinar, thanks for coming back. As you know, there was a lot of content, a lot of material that we try to share with you guys, and we all realized very quickly that there was no way we're going to get it done in one webinar, and so we made the decision to turn this thing into a series for you to provide high quality content and value added for you, just so you can understand all these new changes that are coming about, to make sure that you guys are fully informed, you're ready to evolve and ready to get the maximum out-of-network benefits that you guys are absolutely entitled to, and stop the insurance companies stealing from you.
Hey, this is Sean Callagy. Good afternoon. Thanks for being back, everybody. I know you have precious time and valuable time, and you're investing it in what we're doing right now. With everything, though, if you've heard me speak, if you've been in practice mastery, I think there's such an incredibly interesting element about human dynamics, and that includes all humans, professionals and otherwise. It's not the content and the information that's critical. It's the use of the content and information. And everybody gets really scared when things happen and change. The smallest changes freak people out. They have a problem with their car. It throws off their entire day. They need to get a new cell phone. I tell stories about when my mom was working as a secretary in a law office, and they asked her about utilizing a computer, and she lost her mind and said she'd never be able to learn something like that. And here she is with my 5-year-old nephew, her grandson, as they're like Googling things and posting pictures and doing everything imaginable, from that little device in her hand. Why do I bring this up? I bring this up because we're going to share really valuable and important information. And statistically, under the 80-20 rule, the odds are that the vast majority of people will do absolutely nothing with the information. And that would be crushing and devastating, because we're not here to simply share some information. We're here to help transform actions and processes within your medical practices so that you can get paid. So my focus always is on implementation and the barriers to implementation, which we'll talk about a little bit later. But let's get into the meat of the content. But again, what Michael's about to talk about, and Dan and I, will have no relevance in the world and can do nothing other than be like taking a painkiller for what's going on. So if you just listen to this today, you're basically taking a painkiller. You're doing nothing significant to change the root cause of the issue. But if you implement what we're talking about, massive positive change can happen. I always say believing is free. So there's no purpose in believing that the sky is falling, the world is ending, and that these changes aren't things you can adapt to and overcome. But the more we focus on the problem, the wrongs of the legislature, the problems in our system, the less you're going to be able to, on a day-to-day level, implement change and run your practice and give the highest quality of care to your patients. So with that said, Michael, let's get it going.
So like Sean said, like it or not, the out-of-network legislation is here. It was signed into law on June 1st, and it goes into effect on September 1st, 2018. So whether you like it or not, whether you love it, doesn't matter. You got to comply. So you got until September 1st, 2018 to get into compliance. I'm going to try to move through this material as quickly as possible, but I'm going to give you a really short recap for those who weren't here last time and for those that aren't, to answer some of the more pressing questions that we keep getting over and over again repeatedly. So be prepared and evolve now, right? This act will impact you. There's a lot of misinformation going around that this out-of-network act only applies to emergency and urgent out-of-network services. That is not true. The Out-of-Network Act applies to all out-of-network services, emergency, urgent, inadvertent out-of-network services, as well as elective procedures. So be aware and be ready for this if you provide out-of-network services, because it applies to everyone. So a lot of our medical providers are asking us, hey, I'm going to go in network. That'll be my solution. I don't need to comply with this law. I'll just sign a contract with each of the insurance companies. Guess what, folks? The insurance companies are already rejecting people. They're saying, hey, we have too many medical providers of the same type in this area. The market's saturated, but hey, if you're willing to drop your in-network rate to something lower than what our current providers are doing, maybe we'll let you in. So going in network may be an option and it may not. So if you think that on September 1st, 2018, you're going to make a telephone call and sign a contract and go in network and all your fears are going to go away, that's not necessarily true, and it may hurt your practice substantially.
Yeah, and this is Sean. Of course, we're going to say things throughout this that are going to say, call us. I promise you it's not because we need more work. I promise you it's not because we're hurting. I do assure you we have hundreds of medical practices, 20 hospitals, 80 surgical centers that we work with. Please understand that it is not for us, we're saying, to make a phone call. It is because people negotiate contracts. We review contracts constantly that are utterly disastrous. So if you are going to make that move, you are going to make that decision, please take our help, call us. It's a free consultation. And if you're not going to use us, use someone. Do not do this on your own. Do not do this on your own. And I'll tell stories later on. Please remind me, Nicole, a little bit later to tell some of the stories about people thinking they're going to save a couple of bucks and negotiate something for themselves and the destruction that leads to. Michael?
Yep. So who will the act affect? It affects healthcare facilities and healthcare professionals. Healthcare facilities being ambulatory surgical centers, hospitals, things of that nature. Professionals are generally your individual surgeons, doctors, physicians, neurologists, things of that nature. And the act has different requirements for those two subsections. So you have the facility on the one hand and the professional on the other. A question that we get asked frequently is, will this affect all of my patients? The answer is no. It will impact probably less than half of your patients, but still a substantial amount of patients. We're talking about government employees like police officers, firefighters, teachers, things of that nature. And what's referred to as a fully funded...
Will be affected or not?
It will be affected by this out-of-network legislation.
So just do that quick distinction, Michael.
Yeah, sure. Will and who? So who will be affected? We're talking about what are called fully insured health plans, and government health plans are probably the two largest groups of people who will be affected. Government plans are talking about state employees like teachers, doctors, firefighters, things of that nature. And you also have something called a fully insured health plan or a fully funded health plan. A fully funded health plan means a person called up Horizon Insurance, said, hey, Horizon, I'm looking for a policy of insurance. Can you insure me and my spouse? And Horizon then writes a policy of insurance, underwrites it, funds it, and will pay the benefits in the event that there's any kind of injury. Those are the people who will be affected, right? Who will not be affected? Self-funded health plans, like Coca-Cola Company decides to fund their own health plan and then retain Horizon to provide claims processing services, will not be impacted. Your PIP, right? Automobile accident cases will not be impacted. Workers' compensation cases, someone gets injured at work, a slip and fall, things of that nature, will not be covered by this out-of-network legislation. So know the difference between who will be impacted. This will be the minority for most practices of patients. It will not be the majority of their patients, but still a very substantial sum of patients for most practices. So again, which patients will be impacted? Like I said, non-ERISA health plans, fully insured health plans, state health benefit plans, government plans, things of that nature will be impacted. Now, we talked about this very briefly in the last webinar, and we've had multiple conference calls with a variety of our clients, and this issue keeps coming up very often, and it is very confusing. Self-funded versus fully funded, or self-insured versus fully insured. What is the difference, and what does that mean? So again, quick recap.
How do you know?
Yeah, exactly. So really quick recap. A fully funded health plan is one that Horizon Insurance, for example, actually underwrites, meaning that if a person is injured and claims benefits under a policy of insurance, that it would be Horizon who's paying those benefits. That's what's referred to as a fully funded health plan. By contrast, a self-funded health plan is governed by the ERISA statute, and a self-funded health plan generally is for very large employers or employer-sponsored health insurance. And so what basically happens, the example I keep giving is Coca-Cola Company, right? Coca-Cola has tens, if not hundreds of thousands of employees. They're not going to go out and get tens or hundreds of thousands of policies. They're going to create their own health plan and then get Cigna or Horizon to administer those plans. That's how you tell the difference, whether something's self-funded, which is not subject to this legislation, versus fully funded, which is subject to this legislation.
But it can be very confusing for you as the doctor sitting in your office to know which is which.
That's exactly right. The only surefire way to figure that out is to request the policy or plan documents from both your patient and also from the carriers. And in a self-funded plan, you're talking about something called an SPD, a summary plan description. Most of the time, the employees who have employer-sponsored health plans.
I would say this is like critical moment number one.
Yeah.
Right? Like, well, critical moment number one is that you need to adapt, right? Critical moment number two is requesting the SPDs so you can just understand what you're dealing with. And I'm not talking just, when we're discussing these things today, we're not just talking in the context of the new act. We're talking in the context of running your practice as a business and trying to understand where you are and what's going on. Now, would you agree, Michael, the SPD is a critically important document to make effective decisions about what the benefits are and what's happening?
Yes, that is the document that's going to control the majority of the patient benefit plans that you're going to see are going to be self-funded or fully funded ERISA-based employer health plans. The only document that's going to be able to give you the information about what reimbursement is permitted under the circumstances is that summary plan description.
And we're going to talk a little bit today about how to request that.
100%.
Yeah.
Go ahead, and folks, if you're not getting these summary plans descriptions, you are leaving money on the table.
And a lot of practices, some practices get it all the time.
Yep.
And many practices get it none of the time. So this is one pivot point that you could differentiate yourself from other practices in terms of your level of mastery of running your practice and what you're doing is how effective you are at getting these plans and following the process we're going to outline.
Yep. So we'll talk a little bit more about the summary plan, but also sometimes the insurance card may reveal some of these facts. If you look at the back, for example, of a Horizon card, this is a sample from one of their physician manuals. If you look at the bottom left-hand corner where number 12 is indicated on the slide, you'll see there's certain information about who the funding source is. Fun fact, I pulled out my own insurance card, I flip it over, it literally says fully insured by that insurance company. And so what you're looking for there is for it to say fully insured. If it says fully insured by, let's say, Horizon under these circumstances, then that will be subject to this act, right? If it provides a bunch of other information, such as employer information, the International Brotherhood of Boilermakers, for example, or something along those lines, chances are it's a self-funded plan. So that's one of the things that you want to be looking for to determine what kind of plan you have.
Whether or not the act applies.
That's exactly right. If it's a self-funded plan, the act does not apply. If it is a fully funded plan, the act does apply. So, we're getting a lot of questions in light of talking about the new legislation related to, well, then what do I do when I have a self-funded plan? Again, in the self-funded context, the out-of-network legislation does not apply. And what's happening now with self-funded plans is that, generally speaking, medical providers would go out, they treat a patient, and they get what everybody refers to as an assignment of benefits. It is the standard protocol for treating patients.
I do color commentary, Michael's play-by-play. This is like pivot point number 3. That is extraordinarily critical. So takeaway number 1 is how you're going to manage your own processes mentally and emotionally to make the changes necessary to follow what we're talking about. The first substantive thing we're talking about is to get the summary plan descriptions. Conceptually, we'll give you more on how to do that later. And now we're coming up with major pivot point number 3, which is you're dealing in the land of self-funded and what you need to do to make sure that you're not stuck with what they pay you. Go ahead, Michael.
So what's been happening recently, and it's been for a number of years, and nationally, throughout this country, various states have had to deal with this issue. You have these carriers or the claims administrator throwing a provision into their plans called an anti-assignment clause, which says exactly what it means. It prevents the patient from assigning their benefits to the medical provider. Nationally, courts have agreed that these anti-assignment clauses are enforceable.
Okay, I'm going to jump in, quick point, and we'll go through this very quickly. Essentially, anti-assignment clauses destroy you and your ability to collect, to go file an action to fight against what they paid you. The thing that's remarkable to me is that people fight what they don't like when they can easily do something very simple and very different to defeat that thing that they don't like. So people, we often talk as lawyers. I'll hear other lawyers screaming about anti-assignment clauses, even people in the firm. We've got to fight this and beat this and defeat it on a national level, take it to the United States Supreme Court, because we have argued these issues in front of the circuits. And we will continue to do that. But we blew a hole wide open, and Michael will talk about that now, that gives us an easy pathway to defeat the anti-assignment clause issue for now until more decisions and more issues come up. But this is the essential pivot point number 3. Michael?
So I think Sean hit the nail on the head. So these anti-assignment clauses are being enforced across the nation by courts saying, yep, these things are absolutely enforceable. And if the plan includes them, then you cannot assign your benefits. That eliminates the medical provider's ability to obtain standing, meaning their ability to challenge reimbursements in court or even through the appeals process.
Yeah. So all you need to know is anti-assignment clause could absolutely completely screw you and you're stuck. But we have created a solution through a tremendous victory that we achieved in front of the Third Circuit.
Yep. And so that decision came down about 3 weeks to a month ago now, and it's what we refer to as the American Orthopedic decision. And in that case, the court was asked to determine, 1, whether anti-assignment clauses are enforceable or not, and 2, whether or not you can obtain standing through a document referred to as a power of attorney. And so the Third Circuit just very quickly came down and said, yes, we're going to join our sister courts in various other states and across the country that says, yes, these anti-assignment clauses are enforceable. But, hey, insurance company, not so fast. Power of attorneys are specifically well geared in the medical context, and we think they're appropriate here and can confer standing to the medical provider to bring claims on behalf of the patient. And so while the insurance companies were trying to guard the gate, we blew a hole in their wall, and now the medical providers in what we believe to be an issue in first impression throughout the entire country now has a circuit court endorsing a new strategy in order for you to obtain standing. But it is a distinction on your practice in terms of assignments, and something that we have to be very careful with to implement, because it is very powerful to do, but it has some nuance to it, which is different from the assignment of benefits.
Okay. So simply put, you are stuck unless you do what we're telling you to do. You are stuck. You have no standing, and you have to accept what the insurance company pays you unless you follow this pathway that we have blown open with the power of attorney and comply with New Jersey law very specifically. So you can't just write, power of attorney and put it in your documents. There's additional elements we're going to talk about. And if you don't follow them, you are stuck. You must follow them. You want to be our client. You want us to be blazing this trail, because I don't know of many other firms out there that are filing litigations to go get this money. We are. If you want to be our client, you have to follow this process. Otherwise, we're going to get kicked out of court. And they're going to say you have no standing. You can't be here. You must.
And so when we talked a little bit about nuance, again, it could be a very short document, but one of the things that makes this very different from an assignment of benefits is that the signature of the patient has to be notarized. So you have to get a notary inside your offices to be able to notarize these signatures. Yeah,
and this is the moment where people go, oh my God, I'm going to have to get a notary. Oh my God, I'm going to have to learn how to use a computer. This is the moment that it seems like a big deal. It is not a big deal. It is not difficult or complicated to become a notary. Become a notary. Have somebody in your office be a notary. It is an absolute essential must. Do not pass go. Do not collect $200. You must have a notary working in your office. And by the way, if you fraudulently notarize a signature, that is a crime. And it's a very fast way to lose your medical license and to go to jail and have all kinds of bad things happen to you. Have a notary. It is a must, period. If you want to be out of network, you need to have a notary in your office. That's it. Go talk to some other lawyer who's uneducated in this, who has no clue of what we're talking about. They go, oh, that's crazy. What are they talking about? Great. I've worked with dozens of medical providers who listen to idiot attorneys who didn't know what they were talking about, get them into all kinds of trouble, ending up painting houses in other states because they lost their medical license. And I'm not kidding. Okay, that literally has happened so many times that people in Park Avenue offices in New York City have given people advice that ended up with double-digit fraud judgments against them and others because they listened to them. I'm telling you, you need a notary in your office, period. Michael?
Yep. And so the document that we're talking about here is a very simple document. It's a durable power of attorney. It has a very limited scope in order to give you all the powers that you need to collect on the services that you are providing. And there's certain obligations that are different than an assignment of benefits. There's certain fiduciary obligations related to that, but we're talking about a limited scope of a power of attorney. But all these things are very simple to do. And for our clients, we've been having conference calls, explaining to them the nuances of these and even providing certain documentation to help them in this process.
And the power of attorney, as we're recommending it, cannot be in the name of your facility only. It should be in three names. One is what the facility, but there's some nuances on New Jersey law that say you can't have the power of attorney in corporate name. Do it anyway, but add the owner of the facility and add somebody that works within the facility as an officer. We're saying put in the name of three different people, those three: the owner, the person, the facility itself, and somebody that's an officer or executive in the facility. Because this is the Third Circuit's language was clear about complying with New Jersey law, but these issues have not been litigated yet, right? And we're sure the insurance companies are going to challenge it every way they possibly can. So in the name of all three. Yes, Michael, agree?
Yeah, absolutely. So again, folks, this is another call to action. We do have these conference calls to provide much more specific detail. I don't really have a whole lot of time to spend discussing this issue any further. I want to get back to
call us.
Yeah,
with
absolutely.
Any questions you have.
So we have conference calls, we have calls, we have emails. You can contact us anyway. We are happy to
and
answer.
Our number is
questions.
201-261-1700, 201-261-1700. Call with any question you have. We're happy to give free consultations and advice on this information.
Yep, and we have a question regarding sample POAs. The answer is absolutely yes. So just contact us and we can discuss that issue, okay? So let's get back into the Out-of-Network Legislation Act. So I'm going to be very quickly through the disclosure requirements because I saw Sean yawning a whole lot the last time we did this webinar on the disclosure requirements. But there's 5 key areas that you need to know about this act. You have substantially increased disclosure requirements. You have out-of-network billing requirements. You have an arbitration process that's being implemented. There's a specific prohibition on waiver of patient cost-sharing obligations, meaning copay, deductibles, coinsurance, things of that nature. And then there's some substantial penalties for non-compliance here, which you guys have to be very clued into. So
the bottom line for this is you have to comply with certain disclosures. If you don't, you're going to get yourself in big trouble. And my prediction is the big trouble is going to go far beyond the act. And just like in 1999, when ACRA and the Insurance Fraud Prevention Act, were passed as a part of that, the carriers began using it as a new weapon to become plaintiffs, attacking medical practices. This is going to be the new line of attack. I promise you. I predicted it with ACRA. I represented tons of people. A lot of people didn't listen to me and got destroyed. Right? I was doing this 20 years ago when that happened, and people got destroyed. They ignored it. I've heard friends and colleagues of mine who are out of network have told me that their friends are saying, well, we're not going to comply. They can't possibly enforce all this. I promise they can. And it's going to be in the hands of the carriers that don't want to pay you. They're the ones who are going to be enforcing this. It's not going to be, you don't have to worry about first round, the enforcement from the licensing boards and from the state. That's not going to be the main attack. It's going to be from carriers weaponizing this and putting this into plaintiff causes of action, saying there was non-compliance with this act in the disclosures, and therefore they want full disgorgement from you. That is what is going to happen, guaranteed. Not fear-mongering. I'm factually telling people. It's easy to avoid. Make sure you adhere to the disclosures, and you're not going to have a problem. I predict, I guarantee that is what is going to happen for the people who don't. That is where you're going to get crushed.
And so, the last time I went through a couple of key definitions, we're going to provide a copy of the PowerPoint after this webinar. So I'm not going to go through those things. I'm going to skip right ahead. But all that information is inside the PowerPoint for you guys to review from there.
And Michael, where can people find the PowerPoint? Where are we putting this up?
We're going to put it up on YouTube, and the PowerPoint will be one of the links that we attach.
And how would you find it on YouTube? We're going to call it Adapter Callagy Law.
How about we call it by this wonderful title that we came up with, Evolve or Perish.
Callagy Law, Evolve or Perish.
Yep.
There you go.
And so you just type those in. You can also type in my name, Michael
And we'll
Smikun.
put up on how about we put on the website as well?
Sure, yeah.
All right, we'll put up on the website too. Tiffany, let's make sure we do that. We'll put up on the website and on YouTube.
Yep, and we'll also be sending an email out to you folks as well. So there will be a variety of ways for you to get these spreadsheet, the PDF and the PowerPoint presentation. So I'm going to get right to the disclosure requirements, but I'm going to fly through these things because we covered in the last webinar. Again, new disclosure requirements. The PowerPoint is going to have a lot of details and commentary, but very quickly,
I'm waving Michael forward. I'm waving Michael forward.
So very quickly, folks, the healthcare facilities and the healthcare professionals, basically the same requirements. You have to tell them whether you participate in or out of network. The doctors that are providing the services have to advise whether they're going to be in and out of network. And then the ancillary services, the lab work, the pathology, the diagnostic services, the anesthesia, all of it, you have to identify whether they're in or out of network.
Right. But how? Let's get to that. What are we saying?
So
how do people?
So it has to be both in writing and posted to your website as well.
In writing, where and how?
Generally speaking, the rules have not yet been set by the Commissioner of Health of what the disclosures are supposed to look like. But starting September 1st, do not wait for the Commissioner of Health to promulgate this. Have a writing, something printed out, ready to go to hand to your patients, and also have this stuff.
So why don't we come up with for people a suggested way to comply and write something up as a model or something like that? What do you think?
Okay, yeah, that's fine with me. Yeah. So but again, I would say even though the Commissioner of Health will ultimately decide this, he has not yet. But do not wait.
But that's also something that, as I'm thinking it through, should be specifically tailored, because people could have many different ancillary lots of different interesting things could be happening. So if you want help with that, we'll be happy to help.
Yep.
Yeah.
So again, just very quickly, if you're in network, you have to tell the patient that they will not have a financial responsibility greater than the in-network share. You have to tell them that they will not incur an out-of-pocket expense. And if they are, report them to the insurance companies. That's what it says for in-network. For out-of-network, just very quickly, that certain services that are being provided out-of-network are available on an in-network basis, and that they have a financial responsibility that goes beyond the in-network rate. And in addition to that, they should contact their carrier, such as Horizon or something along those lines. Reach out to them and find out whether there's any in-network doctors available for them, or some of the disclosures that out-of-network healthcare facilities have to begin to provide.
Are we saying so right now that this should be on the wall in the practice, on the website good enough? Is there any guidance, Mike, on that?
So it says in writing and on the website. So there's certain requirements for website and writing. This is prior to treatment, not after treatment has already begun. There's certain requirements that can be made in writing only. It doesn't have to be on your website.
So once you start in the packet, I know guidance hasn't been given yet, but what are we thinking? In the packet is good enough thus far? I think it's better to be safe than sorry, and to make sure all of these documents are included. A belts and suspenders approach is definitely appropriate. In the packet, on the wall, on the website.
Yep.
Is that fair?
Yeah.
All right, we agree, guys? Because James Greenspan, attorney that leads our PIP litigation team and is involved in many of these issues as well, is here. We think on the wall, in the packet, and on the website.
Yep.
Fair?
Yep. If I could just chime in. Hey, everyone, it's James. We had another attorney, Dan Nowak, and I had dinner with one of our clients last night, and they were asking, these types of specific questions. And I think until the commissioner weighs in and does promulgate more specific rules, what we were telling our clients was, a reasonable efforts in good faith to comply with all this stuff.
Right.
If it's on your website, if it's on the wall, if it's in the packet, the intake packet that you're giving these patients, that's going to be good enough until the commissioner comes out and says what you have to do.
But one of the issues is that, right, carriers are super aggressive at times, and you don't want to be cute either, right? So, James, we're not suggesting that we figure out ways to be really cute with this. Let's be, like Michael said, belt and suspenders cautious, because you're a target, right? And we want to make sure that everybody is ultra careful with how they approach it. Let's keep moving.
And so we were talking about certain additional facility disclosure requirements. These have to be on your website, folks. And again, this is all going to be on the PowerPoint. So you can, I'm just going to skip right past it, but you can read about all of those things. And so definitely have a lot of specificity here, both for facilities and for professionals.
What kind of flavor is in there, Mike?
You have to alert them as to if they're out-of-network providers, if they're out-of-network patients and you're an out-of-network provider. You have to tell them whether or not you participate, and if you don't, that they'll be liable for any fees in excess of what they would normally pay an in-network provider, including their copay, deductible, and coinsurance.
But this is not something that anybody in the practice is to orally say.
Well, here's the thing. So prior to treatment, it has to be in writing or on your website for professionals. But once you start treating a patient, verbal is sufficient according to the Act. That's what it says. So, but that
is verbal required. If it's in writing, it's verbal required.
No.
Okay. Because saying this to somebody is a really complicated conversation, and that's why the carriers wanted this language in there. Saying it versus having it in writing in a packet and posted are two very different things.
Yep.
So in terms of just basic human interaction, if it's not verbally required, that is a very complicated verbal conversation, oral conversation that will require a ton of training and nuance to deliver that. Tonality, body language, congruence for everybody dealing with it. It's a lot. Agreed?
Yeah, I agree.
So, I guess our initial suggestion is if it's not required to say, that it would be something probably better put into simply posted on the website, on the wall, in the packet, above oral, unless anybody sees it differently.
Not only do I completely agree with you, but I think even if the insurance company is to come back later and there's an investigation, the patient could always say, I don't remember having that conversation.
Yeah,
so if it's in writing, you can prove, look, I gave it to him and he signed it, so it was delivered.
Absolutely.
So again, I agree with Sean, and it also helps in terms of making sure that you document that these disclosures are being made, which is extremely important. It's not good enough for you to say, yeah, we definitely made them. Document that fact that you're making these disclosures.
It's easy. They're signing 10 things anyway.
Yep.
But the HIPAA, put it in the packet.
So again, all this stuff is available for you guys. There's a lot more nuance to this, but I put it.
And let me just, for clarity, for anybody listening, I'm not saying to hide it and bury it. What I'm saying is it is very complicated to have a conversation with someone saying the things in this disclosure and being a normal place. I mean, anybody who ever watched a pharmaceutical commercial, at the end they list like every way you're going to die from what's happening, and your life is going to be over if you take the pill. That's not what is required here, right? But that makes it really complicated to move forward with the relationship. So I'm suggesting that it's in the packet for all the reasons we talked about. Put it right.
Yep. So the second key feature of this legislation is these new out-of-network billing requirements, which can actually be pretty confusing to providers. And we get asked this question a whole lot.
Yeah, but I'm sorry, but you definitely need to be prepared inside your practice to be answering a whole lot of questions, right, about out-of-network and have answers. And that's not the purpose of this call today. But as we go forward and have additional calls, how you communicate with people and in terms of your human influence, your sales ability, and sales, for those that don't know me, we use the word sales interchangeably with educating, communicating. It's all sales, complete integrity. But the way you communicate about these issues is going to become a very important part of remaining out of network and staying not only alive, but thriving. Your communication skill sets are going to have to be tremendous going forward, as well as your practices.
Yep. So just moving on then into the section regarding the out-of-network billing requirements, the Act now sets forth new limitations on the ability of out-of-network providers to bill covered persons for treatment that was rendered on an emergency or urgent basis, or where, and this is the language used by the Act, where the patient receives inadvertent out-of-network services. Generally speaking, inadvertent out-of-network services, we're talking about in-network facility, in-network physician or surgeon providing the procedure, and then suddenly a pathology report comes back by an out-of-network provider, or anesthesia is provided by an out-of-network provider. The language in the Act is extremely broad and covers a lot of different subjects, but it was the goal of the Act, at least what was shared with us, that the purpose of this was to deal with those situations where you have ancillary services that are provided by an out-of-network provider, although the facility and the physician were in-network. So these billing requirements, or the limitations on the billing, apply in emergency or urgent on an urgent basis, or inadvertent out-of-network services, and generally do not apply in the context of elective services. And so what are the requirements now for out-of-network facilities when they submit bills to covered persons? If you provided emergency or urgent services, right, or inadvertent out-of-network services, you are not to submit bills at an out-of-network rate or in excess of a particular number to the covered person. So that the individual patient who received the services is not liable to pay anything over, generally speaking, the in-network rate, the deductible, the copay, and the coinsurance amounts. The carrier is responsible for that. So there was some confusion that goes, wait, so on emergency services, I don't get paid my out-of-network rate? That's not true. It's the patient who is not responsible to make those payments, but the carrier is. The carrier is obligated to make those payments. And so the new out-of-network billing requirements deal exactly with that. and that if you have an issue in terms of collecting from the carrier, or you have an issue with the amount of reimbursement that you're getting from the carrier on emergency or urgent basis or inadvertent out-of-network services that are provided, you could submit to this new binding arbitration system, which is created also by the Act, and I'll discuss it in the next section. So in addition to some of these out-of-network requirements, there's also a lot of additional notification requirements that are required from the out-of-network providers. And I keep talking about these new disclosure requirements, but the more we discuss and we educate our clients about these things, the more they realize that they're really not as bad as it seems. A lot of these disclosure requirements are new. Some of them are nuanced. But the reality is change is inevitable, right? We're going to have to evolve in order to make these disclosure requirements. And once you have a firm grasp of what actually is required to be disclosed, suddenly it doesn't look so bad. And I see James sitting up in his chair because he was part of some of these education processes. The more we deal with our own clients and share with them the details of the disclosures and how to make these disclosures, the more we're hearing from them, oh, it's not as bad as I thought it was. This is not the end of out-of-network benefits. So there's definitely nuance here. I don't want to create all doom and gloom. There are disclosure requirements, but it's not that much that it's going to, be impossible for you to practice. There's also certain requirements about annual reports that have to go to the Department of Health, but that's all talked about in the Act more specifically. The same requirements for the facility really applies for the professionals as well, so the individual doctors. Again, over the in-network rate and the cost-sharing requirements, you are not to bill the patient over and above those amounts, but you can still collect them from the carriers, right? So all of those payments still have to be made by the carrier, and there's also this requirement of the arbitration, or the ability to access arbitration, which has somewhat tight deadlines in order to get these things done. One of the interesting features of this Act, and nobody's really talking about this, is that the language of the Act does not make the arbitration process binding, right? It's not mandatory like a workers' compensation claim has to go to the into workers' compensation court. So arbitration is an option, but it may not be the only recourse that the medical providers have in order to get reimbursement under these circumstances. And so the Act speaks pretty clearly on this thing. It doesn't say that it doesn't create an exclusive remedy, but it doesn't say that it does, which means to us as attorneys who certainly like to analyze things and go into depth on a lot of these details, that you can still litigate these cases as well.
Yeah, so what we're going to be recommending to our clients to do is we're going to experiment, and we're going to figure out how effective this process is for the claims that it applies to, right? We're going to figure out how effective it is, because this is not about us. It'd be very easy to say, hey, give us your claims and we're going to make money from an arbitration process. But we want to make sure this is going to be effective. It's going to be fair, right, for the providers. And I have some hope that it might be, right? Because I think that, that they're looking at making it at some levels, James, correct? Similar to the PIP process. So we have some hope. Go, James.
It's essentially that once the carrier receives the bill, they have 20 days to pay it or deny it. And then there's a 30-day window in which there are negotiations between the carrier and the provider. Ultimately, the carrier has to make their final offer and pay that offer. And then if arbitration is commenced by any party, the carrier is stuck with that final offer that they will have already had to pay. The provider can make their final offer within the arbitration, and it's a baseball style arbitration, which I think we're going to get to in a little bit. But that essentially means it's either A, the carrier's number, or B, the provider's number, and there's no compromise in the middle. The arbitrator doesn't get to say, well, you're here and they're there, so I'm going to split the baby and I'll use amount number C, letter C. So that encourages the parties to be submitting reasonable numbers that they can support. So that's, I think, what Sean's referring to when he says it's really fair for both parties. The providers are going to get to say, here's our EOBs, here's what other carriers are paying us, here's where Fair Health supports us. So this really is a truly reasonable number. And if all of the data and the evidence is supporting your number, I think it's likely the arbitrators will rule in favor of that number.
Yeah, but remains to be seen, right? So we're hopeful, right? Yeah. But it remains to be seen. So we're not applauding this. We don't think this is good or bad yet, right? We
Right.
think it's interesting. If it works, then it's great. It's a wonderful alternative to the litigation process, just like the PIP arbitration system, has its flaws, but I think it's a terrific system, quite frankly. We'll see. So, Mike.
Yeah, and so there's a couple of questions that are bouncing around. If we have a patient with out-of-network benefits and they elect, right, to go out of network and get treatment from an out-of-network medical provider, can you still submit the bills to them? The answer is absolutely, unequivocally, yes. Right? The Act does not eliminate the ability to bill out of network when patients make a knowing, affirmative decision to go out of network. The ultimate question is, what does that look like? The language there is waiver. It's going to be a little bit more comprehensive than just signing a waiver. There's certain language within the Act talking about the level of knowledge that the person has when they make that determination. But once you've overcome that, you have out-of-network benefits the same way you do today. So you're providing services, you're submitting bills to the insurance companies, and you're getting reimbursed for your out-of-network benefits. But we were touching a little bit about, upon the arbitration issues. And again, it doesn't appear to be a mandatory arbitration, but it may be a really great opportunity. A lot of people are talking about some of the filing thresholds and things of that nature, and I'll let James weigh in here if he wants to add anything in terms of color commentary to what I'm going to share with you. But basically what you're looking at is, carrier makes a proposal as to what they're going to pay you. You make a proposal as to what you're looking to get paid. And as long as the threshold is between $1,000 or greater, you can always initiate, either you or the carrier can initiate the arbitration process. James talked a little bit about the time frames and things of that nature. The carrier has 20 days upon receipt of the bill to select one of the options, which is pay the bill, pay what they think is reasonable and begin negotiations, or make no payment and begin negotiations, essentially, in order to move that process forward. So, one of the questions that we've been asked repeatedly is, hey, I know this the statute kicks in on September 1st, 2018. What should I be doing with the claims that I have presently? I don't want to be, run afoul of any of the rules. And if you have services that are being provided now and you have claims ready to go, submit them, right? Submit them for processing a payment immediately. There's no reason for you to be sitting on claims. I think the out-of-network legislation is only going to make that process more challenging. And I certainly don't think that you're going to have any benefits of holding on to the claims to take part in this arbitration process, because we just don't know how this information is going to turn out. There's going to be some growing pains. There's going to be some issues at the outset. And so we don't know what reimbursements are going to look like at that point. If you hold on to these bills and submit them on, let's say, on September 1st, in all likelihood, they're going to be subject to the requirements of this legislation. I don't say with all likelihood. I will virtually guarantee you they will, although the Act is not entirely clear as to when the legislation triggers with regard to the submission of claims. But I'm going to venture to guess, and I feel pretty strongly about this, that it's September 1st, 2018. I think that's what the carriers are going to do, and that's what the legislature probably intended in terms of setting that date. So get those claims in, submit them now, and get them reimbursed. You do not want to be going through this process cold, sitting on a whole bunch of claims that you're holding off on, thinking this is going to be a beneficial situation for you guys. It's hard, like Sean said, like James said, it's hard to tell one way or the other whether it's going to be positive or not. But I don't think you guys should be risking these claims, hoping that it's going to be. So we got some time frame requirements. Interesting fact, for some reason everybody's touting this as a huge deal. But if you're providing emergency services to a patient, you no longer need to obtain an assignment of benefits. The legislation creates an automatic assignment of benefits.
Where the Act applies.
That's exactly right. So it would not apply.
So you still need to follow the power of attorney information we were talking about, right? Right. But where the Act applies.
Yeah, and so we're talking about PIP claims, workers' comp claims, all of those still need assignments of benefits. So nobody should stop doing and obtaining assignments of benefits merely because this Act applies in one specific situation. Automatic assignment of benefits. I think that's very dangerous for your practices to be foregoing the assignment of benefits, because even though it doesn't apply in the self-funded context, which again is not subject to this new legislation, Assignment of benefits still work in PIP, they still work in workers' comp, and they work in a variety of other places as well. So do not stop doing assignment of benefits merely because this act came about.
And just remember that at the time you're rendering those emergency or urgent services, you're not going to know which bucket this falls into, whether the act is implicated or whether it's an ERISA claim. So, as Mike was saying, with the intake paperwork, you're going to be needing to get the powers of attorney, assignment of benefits for PIP. So just because you don't need the AOB when the law applies doesn't mean you should stop getting it and including it in your packets.
Real quick, as Michael's flipping through to the next piece, I just want to share, a quick 2 minutes that I come back to it. It's a fair break time to throw it in about negotiating things for yourself. So we have a dear client in Arizona. That was the result of the case many of you heard us talk about. And I'll share for 10 seconds what that means in a second. This person has built multiple massively successful companies, built and been a part of. Super smart guy, was making $500,000 a year as a salesperson at his apartment when he was 6 months out of, or maybe a year out of college. Just incredibly persuasive, very sophisticated, person in terms of business and business acumen and issues. And he was penny wise but dollar foolish in some decisions that he made. He did not get the right advice and did not build an operating agreement in the partnership that he had. So he negotiated something for himself, like we're telling you not to do, particularly when you're dealing with carriers and out of network, but even within your own operating agreements and structures. Because he didn't do two things, and I could go through 10 more. He ended up, he and his former partner combined spent over $25 million in legal fees litigating an issue. And we offered to settle that case for $3 million. The other side spent $17 million defending. $3 million spent $17 million defending. It took 7 years and ended up in the $27 million jury verdict that we got him, largest in Arizona. But none of that would ever have been necessary or happened if two things. One, he had in his agreement the ability to fire his partner if certain behavior was engaged in. He got beat up, physically attacked, humiliated, outrageously insane things occurred. And the court found before we were involved that he had no authority to fire his partner. That resulted in filing for dissolution and all kinds of horrendous things that happened from there, but he never would have had to file for dissolution if he had the ability to fire his partner, number one. Number two, he also never negotiated a loser pays attorney's fees provision. Had he, as much as we got him, it was unbelievable and staggering because the $16 million punitive damage award, you could have thrown on top of that a nearly 8-figure attorney's fee award on top of it, which would have occurred. I use that to simply illustrate. These guys were best friends. They knew everything, super sophisticated. Do not overestimate your acumen. Do not overestimate your intelligence and knowledge, no matter how smart you are. If you went to Harvard Medical School, or if you went to the School of Hard Knocks and you're smarter than everybody else, you make a fortune in your business. People are cheap and make dumb mistakes about not utilizing lawyers, including me. And I've made the same mistake, even though I am a lawyer, or I've been sloppy. It's dumb. Don't do it. Have people help you. Do not be penny wise but dollar foolish. And I could line up 50 people to talk to you and tell you how insane that is. And that is not a pitch to get your money. I am telling you, use us or somebody who knows what they're doing. By the way, that may be a little harder said than done. Okay, somebody who knows what they're doing. Look into these issues and get the help you need to structure your practices accordingly. Michael, agree?
Yes, absolutely.
Is it one word I said untrue? You litigated that case with me. Would that have avoided massive amounts in that litigation if those two things were in there?
Yeah, it would have been over before it started.
Right. And by the way, he did have an attorney. He had an attorney who was his best friend from college who was a categorical idiot. Terrible, ridiculous, and he should have been sued for malpractice because he didn't have those things in there and destroyed the entire process because he had a buddy. Oh, my buddy's a lawyer. Well, my buddy do it. He knows what he's doing. No, he didn't. And that's what happened. Thank God for us because we won in the end, and that's what my client says, not just me. Michael?
So
does our client say that?
Yeah, absolutely, 100%.
Okay.
Yeah. So building on that fact, I think if you're going to move forward with these arbitrations, what you need to know is you need to be able to support your fees. And so probably the best source of that information is your own EOB showing that payments were made, that they were reasonable, that they were paid by a variety of insurance companies at the rate that you charge, showing usual, customary, and reasonable reimbursement rates. You may want to look to certain national databases which have issues, right? Fair Health, Ingenix, Wasserman.
All of which, by the way, we can help you do and organize and structure within your practice.
Exactly right. And we have access to a massive database of our own EOBs from a variety of providers and things of that nature, which are all redacted, all information excluded. But we have a tremendous amount of information. We have access to these databases and things of that nature. But expect from the carrier that you're going to be seeing them pointing to Medicare and Medicaid as the reimbursement that you should be receiving. Now, the one thing I'll say about Medicare and Medicaid, and this is a little bit of value added for the conversation, the one thing you need to know about Medicare, Medicaid, and in-network rates and things of that nature is there's a trade-off, right? You're trading volume, meaning additional patients for lower reimbursement levels. When you're an out-of-network provider and you obtain your patient through, as an out-of-network patient, you're not getting the benefit of that. So how unreasonable and how unfair would it be for you to not get the benefit of an in-network contract or being a Medicare, Medicaid doctor and getting the patient through that mechanism, but have to eat the fees in the same manner that it would? And I think that in those circumstances, and I have a feeling that a lot of judges and a lot of arbitrators are going to agree with this, that is an unfair and unreasonable methodology to use. But you want to be able to support your bills and you want them to be reasonable. And we have a long track record of having done that using exemplar EOBs and databases and things of that nature. But again, as Sean said, we have a huge massive database regarding those things, so we can certainly help in that regard. But give us a call. We're happy to answer questions in that regard. So again, I'm going to go really, really quickly now because I see the time is short. We have the arbitration process. It's baseball style, means it's their number, your number, or nothing. There's nothing in between.
That's why we do not suggest that you negotiate this on your own either. This is something that developing a system intelligently to maximize this process becomes critically important. And the breadth and knowledge that we're going to acquire very, very rapidly, because we'll be doing, I would argue, I'm very confident we'll be doing more than this than anybody else in the state. We're happy to help you and set up the processes for success. So,
yeah, absolutely. Because time is short, again, the PowerPoint has all this information for you. We're going to be providing that to you guys. But I want to talk about the prohibitions on the waiver of patient cost-sharing obligations and the penalties that can come for violation of this act.
And I don't like talking about negative stuff and limitations of doom and gloom. But this is the next major pivot point. And if people don't get their act straight here, this is going to be a major catastrophic event for practice. And it's coming, and it's going to come hard and fast. This is critical how you operate in this space.
So the act specifically talks about the language that it uses is that it will be a violation of the act if you directly or indirectly knowingly waive the deductible, copay, or coinsurance requirements of the covered person.
Right. And think about the breadth of that language.
Yeah. You want me to do it one more time?
Yeah.
So it will be a violation of this act if you directly or indirectly. Yep.
How the hell do you indirectly waive this? Right. So that gets complicated.
Yep. Knowingly waive as an inducement for the covered person to seek healthcare services from that provider. Basically, what this says is you cannot waive the coinsurance, copay, and deductible generally, or it will be considered a violation of this act, and you will have to deal with the penalties that I'll talk about in just a second.
Right. So I want to set this up really quickly for 60 seconds. You have a conversation with your office manager. You have a conversation with your front desk person, and you go, okay, so how do we kind of get around this? And what do we do so that patients are still comfortable and want to come in and blah, 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 blah. That conversation will eventually be discoverable in a deposition where they'll be saying that you were knowingly and intentionally trying to create an inducement fraudulently to get around the act, and you have people in your office being asked those questions. So every conversation you have about this from this day forward, or God forbid, put in writing, is going to be critically important. Okay, so hear me. This is what I know how to do. This is why we won $27 million in Arizona and $33 million in another fraud case. We have litigated the plaintiff version of the fraud case. The carriers are going to become the plaintiffs. Understand the conversations, the text messages, the things you put in writing about fee forgiving, approaching it, all these economic issues are wildly important. And if you think I'm kidding, I've litigated these cases with carriers for 20 years on the PIP side. where they're talking about in-kind kickbacks and every other issue under the Fraud Prevention Act. I know what I'm talking about. This is not fear-mongering. I've lived through dozens and dozens of these depositions with the craziest questions, framing on videotape, and I'm telling you, unless you've sat through it, you think I'm talking about some fairy tale. I am not. I promise you. So we have to be strictly compliant with these provisions. Have to.
Yep. And so I think Sean hit the nail on the head. Now,
What have I done? Just you have to give people pain to pay attention, because people think this is not real. What have I done to people in these depositions, and you've done with people in depositions who are trying to lie and be cute?
Yeah.
What happens to them?
They get dismantled. People come in, they say, I don't know, I don't remember. We've seen people break down in depositions, cry, admit.
We've made people break down, cry, and get destroyed.
Absolutely.
Right? And there are going to be people. Most lawyers are not going to be able to do that, but there are some that are out there that will. And you do not want to be on the wrong side of this. So the way to prepare now is not prepare when your deposition is coming up and the factual basis is a mess. It's to make sure the factual basis is pristine and clean from day one, starting now.
Right. And so, again, the act is a little unclear as to how this is going to be enforced or what this will constitute. But knowing this language directly or indirectly, knowingly waive as an inducement for the covered person to seek healthcare services from that provider. The second part, there's no clear information yet from the commissioner as to how this is going to be enforced. But I think the next section of the act and the language here is really, really important. It literally says the commissioner shall prescribe by regulation what it means to be a pattern of waiving, right? A pattern of waiving, and what shall be considered an inducement.
Right.
And so although
what I keep saying is I'm not really worried about the commissioner, right? I'm worried about the carriers using this as a weapon. So they're going to be the ones who are attacking and pushing the envelope on what this means. So everybody's like, well, how could the commissioner ever work on enforcing all this? It's not going to be the commissioner. It's going to be and you go, wait a minute, the carriers don't have the right to do that. It doesn't say they can. Yeah, but they will. That's what they're going to do. They're going to create fraud cases about this using this language. That's what's going to happen. That's the problem.
Yeah, and by the way, folks, there already is a proposed legislation that's being put into effect that adds the violation that we're talking about here into the Insurance Fraud Prevention Act.
Which is treble damages,
Yep.
attorney's fees, and by the way, says that a waiver of a jury trial. You want to talk about a problem? And that's something, if you want to fight for something and have different organizations band together, be fighting for change in the Insurance Fraud Prevention Act waiver of a jury trial or preclusion of having a jury trial. That is death to medical provider defendants, right? Because people hate carriers, they know it, and they put this stuff in front of friendly judges that have been politically appointed, right? And that's the reality. And that's what they did with Judge Villanueva, who was an absolute corrupt judge back in the late 1990s. And I say corrupt. It was outrageous. I appeared in front of him. I filed the motion saying he's biased. I speak it like it is. The guy was corrupt. God rest his soul. He was corrupt. It was utterly ridiculous, completely biased, and outrageous, the things that he did. So you do not want to be in front of the wrong judge making these decisions. That's carrier friendly. And that's a huge issue that gives the carrier benefit, because you want to put in front of a jury of normal people who make fair and unbiased decisions. And if this comes under the auspices of the IFPA, that's a disaster that should be repealed and or amended. Yes, carriers have a right to sue people for insurance fraud, but it's outrageous how that's been passed and what doesn't require.
Yeah. And so just really quickly, the commissioner will promulgate these rules. They're not there yet. But folks, if you're telling your patients, come treat with me, don't worry, we don't collect our co-insurance, copay, and deductibles, that is going to put you in the crosshairs. What conduct actually will put you in the crosshairs is a little bit of a question mark, but I can tell you unequivocally before the commissioner says anything that if you tell your patients we are waiving our co-insurance, deductible, and copay if you treat with us, that unequivocally is a violation of this act. So do not be doing that. Do not be communicating that directly or indirectly, and make sure that you're attempting to collect these copay, co-insurance, and deductibles in good faith, right? Some people are indigent. Some people don't have the ability to make these payments. And there are still safe harbors under this act about hardship and things of that nature that exists. But if you are specifically and expressly saying we will not collect co-payments, co-insurance, and deductible, you are in violation of this act. Do not do it. So just really quickly about penalties, the penalty for violation of this act is $1,000 for facilities for every violation, to a maximum of $25,000. But as Sean said, that's not really what matters. there's going to be a referral to the Office of Insurance Fraud Prosecutor for multiple violations of this act. Without a doubt, unequivocally, the act specifically says it. So the $1,000 a day penalty is strict, or $1,000 for each violation, up to $25,000 is a harsh penalty. But believe me, the more stricter penalty is going to be the lawsuit that you're going to get from the insurance company and the Office of Insurance Fraud Prosecutor knocking at your door and starting to ask questions about why you're in violation of this act.
And we say this, guys, I keep repeating it, out of care, right? Care and love. We're telling you that you have to comply. You have to, right? This isn't something that can be overlooked, can be avoided. It is going to result in they're going to sue you and claim every dollar back, whether or not the treatment was reasonable and medically necessary. It's what happened under the IFPA and ICRA. It's what's going to happen. So we don't like to talk negatively. We said that this isn't the end, all those things, but it is. I don't know how much we could possibly emphasize the absolute necessity of compliance, otherwise facing life-changing disaster.
Yeah, and so facilities, $1,000 per violation. For professionals, it's $100 per violation, up to $2,500. But again, the referral to the Office of Insurance Fraud Prosecutor and the inevitable lawsuit from the carrier is going to be where all the action really lies in terms of the penalties under this act. But know about them, know that the violations will have that happen. So, wow, what do I do now? All this doom and gloom. Well, look, the legislation is here. There's nothing we can do about that now. The only thing we can do is evolve. And I really mean it when I say evolve or perish. Because if you're not getting into compliance with this act, you will be destroyed. If you do get into compliance with this act, which is not as challenging as it seems, the disclosure requirements and things of that nature, you can have a prosperous out-of-network practice. It may not even be impacted at all. And by the way, folks, if you're really putting these practices into play, you're increasing your salesmanship, you're increasing your influence skills, you're increasing your connection to your staff, you're increasing your process management and things of that nature, it may actually increase your revenues and things of that nature. And maybe you had to be looking at these things now, and this is just a wake-up call for you folks to get all those things in order. Again, some of you are sitting here and going, "Oh my God, Michael, you just spent an hour telling me about all this doom and gloom. I'm going in network." That may or may not be an option for you folks.
And it may or may not be the right option, even if it is an option, right? And so let me say that again. What Michael just said very quickly is that sometimes, we spent 7 years in a case where they tried to say that we violated HIPAA. They tried to refer us to the Attorney General's office of the state of Arizona. We ended up taking the case substantially on a contingency over time, and it was some of the most difficult, pressure-filled, insane times. Michael went through tragic personal loss during the process. I went through some incredibly traumatic things myself. It was life-changing. When it started, my son was 11. When it ended, he was 18, graduating high school, all of this. I look back on that journey as some of the most valuable time of my life. And there's 50 incredible benefits that happened from being faced with that adversity and challenge. It made me realize that I can congruently tell people that I'll stand toe-to-toe with any trial lawyer in America, and quite frankly believe I'll stand above toe-to-toe. It made me know that Michael is that good. It made me know our team is that good. It made me realize what it takes to operate at a national level and defeat national level lawyers who think they're better than they are, et cetera, et cetera, et cetera. Dig deep. It made our client a better human being. He said that to me, in fact, on the phone this morning. It made me a better human being, in fact, right? And dig deep inside of myself and find more. And I think all of us, every person involved says it was wonderful, and everybody would never have wished it in their worst nightmare that happened. So as Michael said, there's a lot of things that could come out of this, including the overall improvement of your processes inside your practice, how much money you're collecting, because there's probably significant deficiencies there to begin with. Even if you're operating at a very, very high level, there's always opportunity for growth. Maybe it involves additional getting out there and marketing and building relationships and all kinds of different things. Who knows? But the point is that whether you believe you're going to succeed or fail, you're right. We implement and we create the actualization of what we believe. And we always say believing is free. Take your time, take a deep breath in terms of making a decision globally what you're going to do. Our very strong suggestion is attempt to comply and operate through this process as you go. Maybe explore the idea of going in network at the same time, and leave yourself open to a variety of different options as you move down this path. We're here to be a resource, hopefully a valuable resource and a close one. please call us. Many of your clients are ready, many of you are not, but please have an optimistic and positive deal with the, good to great says deal with the brutal truth, but be optimistic that you're going to get to the other side and achieve your goals. Michael?
Yep. And by the way, David, thank you as well for that. I just want to go a little quickly
David,
through
thank
this.
you for.
Somebody said thank you on the
Okay,
on the chat. So just quick 30-second statement about how we can possibly help you with this. As I said, you have to increase your communication with staff and patients. You got to improve your processes. You got to give your patients an experience and not just the service. And come to Callagy Law Practice Mastery, right? What can Callagy Law do to help you in this process? We have mastery of the arbitration process. We've been doing this for over a decade now in terms of arbitration for PIP cases. We do litigation, workers' comp, things of that nature, which I'll talk about in just a second. Help you to maximize your collections by using our caring, urgency, and aggression to produce unique and efficient results for you. Provide model documents to enhance your processes as you get into compliance with this act. We have client liaisons available to you, which can help in terms of administrative and dealing with other issues that you've been that you may have to contend with in terms of getting into compliance with this act, and access to dozens of attorneys, some of which are sitting inside this room, which can provide you the answers that you're looking for. So what is it that we do? I mean, it certainly goes well beyond litigation, as Sean shared. It goes well beyond the webinar today. We do all facets of medical revenue recovery, PIP, work comp for medical providers, commercial insurance, and ERISA litigation. We have healthcare transactions and compliance, healthcare litigation work, business and commercial litigation, family law.
If you have a legal problem, call us. If you have a legal problem, call us.
Yep.
Right. Legal question in any area, call us. Number one. Number two, we're here to help you shift the mindset to the most optimal one you can. We're involved in coaching and training programs ourselves. We bring that information back. I'm a part of Tony Robbins' Platinum Coaching Program. I was at his house for his birthday in a cold spring at 41 degrees at midnight in a snowstorm and singing happy birthday at night. You go, well, Tony Robbins is a goofball. Really? He's coached presidents. He coached the Golden State Warriors and helped turn their team around this year. His technology information is absolutely unbelievable. I coach with other people, go through tons of programs on marketing, sales, leadership, all of that, as well as all the folks in our law firm. So we're here to provide tremendous resources and help. Our next practice mastery is that up, Mike?
Yep, it's on here. It's June 27th at 6 o'clock p.m. at Crown Plaza in Edison. Again, that's June 27th at 6 p.m. at Crown Plaza, Edison. You guys are all invited. Just we'll reach out via email so you can send in an RSVP if you're interested in coming. And our next webinar is going to be talking more specifically about the self-funded insurance issues related to the Third Circuit's opinion in American Ortho, which we touched upon today. We also have new content daily on Facebook and YouTube, so we hope you check us out there as well.
Yeah. And listen, when it comes to practice mastery, there's a lot of providers and owners of practice that go themselves. Awesome, as well as bring their staff. Some just send their staff. You're more than welcome to do that. Just send your staff. It's free, by the way, of course. But please come. Please come. It's a great night to ground yourself, think about your practice, think about your goals and outcomes. And I'm not suggesting to you to do something I don't do, right? I'm going to be heading off to France for a week. I was in this will be the third time I'm going to be spending multiple days away from my practice this year alone to work on building my practice and making it better. These are things I do regularly. Coming to practice mastery once a month for 4 hours is not a significant investment of time into your practice and business building. And I'm very confident that you get information and material there you're not going to get somewhere else, including being reminded of why we don't do things, which is basically rooted in fear, the psychology, right? Our self-mastery is the most significant reason we don't succeed at the level we want to. And that's what this is all about. Anybody else have anything else?
I have nothing else. Thanks, folks.
Yeah, thanks, guys. I know it was a huge investment of time. Call us, 201-261-1700. As Michael said, follow us on Facebook. The information will be out there. Please come to Practice Master on June 27th, whether or not you're our client. Thank you.